Hello, everyone, and welcome to the second summer 2014 installment of your Liberal Bootcamp. My name is Colin Howard. I'm a rising sophomore in Columbia College, and today's Liberal Bootcamp is about corporate personhood, an issue that's been making the rounds recently. As many of you already know, under the Patient Protection and Affordable Care Act, also known as Obamacare, employers are required to provide health insurance to their employees. The Act provides that all such healthcare plans must include a minimum level of preventative care as specified by the Department of Health and Human Services, including free access to all 20 FDA-approved contraceptive treatments. Hobby Lobby, an arts and crafts store that employs about 21,000 people, disagreed with this mandate, so in 2012, the owners of the corporation sued HHS, claiming that paying for contraceptives imposed an unfair burden on their religious beliefs. The Supreme Court recently ruled 5-4 in Burwell v. Hobby Lobby Stores Incorporated that a closely held corporation is a person with the same right to the free exercise of religion as a natural person. The court bases its decision on the Religious Freedom Restoration Act of 1993, which states that a neutral law of general applicability cannot, quote, substantially burden a person's exercise of religion. The act was passed in response to a 1990 Supreme Court decision in which, interestingly, Justice Antonin Scalia said that to allow a person to defy generally applicable laws on the grounds of free exercise would, quote, make the professed doctrines of religious belief superior to the law of the land, and in effect to permit every citizen to become a law unto himself. The majority of the court in the Hobby Lobby decision, which consisted of the 5 conservative-leaning justices, claimed that because the word person in the Dictionary Act is defined to include corporations as well as individuals, Hobby Lobby Stores Incorporated has the same rights as a person. Now, the court declined to address the free exercise clause arguments made by Hobby Lobby and instead relied just on the RFRA. But Justice Ruth Bader Ginsburg argued that because the Dictionary Act only applies where context does not indicate otherwise, the court should have referred to previous free exercise case law, where there is no indication that a corporation's rights are comparable to those of an individual. Corporate speech is restricted far more than individual speech. A corporation cannot make public claims in bad faith. The Supreme Court has ruled again and again that corporations do not have a Fifth Amendment right against self-incrimination. Corporations do have 14th Amendment rights, but only to protect them from arbitrary action of the government and to give them due process, not to protect them from regulations particular to corporations. For example, corporations are taxed differently than individuals. And most importantly, corporations cannot vote. Neither the Declaration of Independence nor the Constitution contains the word corporation, so all the rights they have gathered were declared in statutory law or inferred by the courts. There is historical reason to believe that corporations were deliberately left out of these founding documents. Chief Justice John Marshall, in the same case that decided that corporations could in the first place make contracts, Dartmouth v. Woodward, declared that a corporation is an artificial being, invisible, intangible, and existing only in contemplation of law. More to the point, Thomas Jefferson wrote in 1816, quote, I hope we shall crush in its birth the aristocracy of our moneyed corporations, which dare already to challenge our government to a trial of strength and bid defiance to the laws of our country. None of this is to say that corporations should have no rights. Rather, corporations should not be entitled to the same constitutional freedoms as natural persons. Moreover, corporations should never have the ability to harm an employee's health, which is exactly what SCOTUS just declared. And they should never have the ability to force their owner's religion on any employee, especially when that employee is a member of a group that has been historically oppressed, such as women. But I digress. Corporations function as more than a form of organization for their people. In this instance, the whole is greater than the sum of its parts. Corporations deliver profits to shareholders and wages to employees, and hold assets no one individual could conceivably hold. This is, of course, why corporations are a good thing. They help their people pool their resources, knowledge, and talent. But corporations survive past the human lifespan, making them more powerful than people. They also, importantly, buy and sell each other. As natural persons, we human beings are not each other's property. In these ways, corporations are very much unlike natural persons. But more intuitively, corporations have no beliefs, no thoughts, no consciences, no feelings, no sentiments. They are not born and they do not die. They do not breathe, they do not eat, they do not sleep, they do not think. They cannot have children, they cannot pray, they cannot experience grace, or hope, or happiness, or sadness, or gratefulness, or devotion, or rebellion. They do not dream, and most definitely, they do not have the capacity to love. Ask a child what defines a person, and they will tell you some combination of these things. A corporation fills every single one of these tests. The precise semantic difference between saying a corporation is a person and corporations are people is that the first is a legal simplification that allows corporations certain limited rights, and the second implies that corporations are equivalent to natural persons, which is, of course, absurd. I'd like to spend a few minutes now discussing Justice Ginsburg's well thought out, passionate, brilliant, and frankly badass dissent. She begins, in a decision of startling breadth, the court holds that commercial enterprises can opt out of any law, saving only tax laws, they judge incompatible with their sincerely held religious beliefs. She goes on, there is no support for the notion that free exercise rights pertain to for-profit corporations. The absence of such a precedent is exactly what one would expect, for the exercise of religion is characteristic of natural persons, not artificial legal entities. She also pointedly notes that the real suppression of free exercise, in this case, comes not at the hands of government, but at the hands of the corporation denying healthcare coverage to a woman who must be able to make an autonomous choice informed by the physician she consults. Justice Ginsburg poses a number of hypotheticals that demonstrate the broad scope of this decision. Suppose an employer's sincerely held religious belief is offended by health coverage of vaccines, or paying the minimum wage, or according women equal pay for substantially similar work. Would the exemption the court holds RFRA demands for employers with religiously grounded objections to the use of certain contraceptives extend to employers with religiously grounded objections to blood transfusions, such as Jehovah's Witnesses, antidepressants, Scientologists, medications derived from pigs, including anesthesia, intravenous fluids, and pills coated with gelatin, certain Muslims, Jews, and Hindus, and vaccinations, Christian Scientists, among others? The fact that the court singled out contraceptive treatment, which has been legal since 1965, is clear evidence of misogyny and the Republican war on women, but that is another liberal boot camp entirely. Further, as she points out, although the court attempts to cabin its language to closely held corporations, its logic extends to corporations of any size, public or private. The implications of this decision are broad-reaching and potentially devastating. This is what happens when you let corporations pretend they are people. So where do we go from here? We can take several actions as Democrats to protect women's health. We can petition insurance companies to ensure they won't sell plans without contraceptives. We can also help out any movements to ensure corporations won't give their employees poor insurance plans. But we should also take action regarding corporate personhood. We can test the waters for a constitutional amendment that would clarify that corporations should not be considered equal to natural individual persons. We need to emphasize political willpower here, especially of women and other marginalized groups, and not wait for the SCOTUS to realize that its invention of precedent is harmful to real people. And finally, we must be constantly mindful of falling into the logical trap that because corporations are made up of people, they are people, and that they can have religion too. To use Ruth Bader Ginsburg's words, the court, I fear, has fallen into minefield.